guys, my name is Alina Shaltsova. I'm an immigration attorney from New York. In today's live, we're going to discuss the most recent immigration news. We're going to talk about what Biden's administration is doing, if anything, with regard to the prosecutorial discretion situation. We're going to talk about TPS and specifically TPS for Venezuela. And what you need to do is, if you're one of the people who may be affected by the recent decision, we're going to discuss USCIS flexibility and the end of it, basically. So thank you very much for joining. Please like, share this video so more people are going to be able to join us. Don't forget to tell me where you're watching from. Say hello. And we are going to start. Well. So what's happening? Interestingly enough, which of course I personally hope for, the Biden administration is going to United States Supreme Court to fight for you guys, to fight for prosecutorial discretion. If you recall, July 5, July 6, July 7, several courts too issued different decisions with regard to the same topic, whether or not the Biden administration can exercise prosecutorial discretion pursuant to a special memo, pursuant to the guidelines the Biden administration implemented when they took over the office. Basically, those guidelines would focus government's attention, ICE officers' attention, only on those undocumented residents who do not have, or who rather have, heavy criminal convictions. They present danger to public safety or national security. So not everyone liked it, as you know. Some states sued the Biden administration, and they were, to this point, some of them were moderately successful in blocking that prosecutorial discretion memo that would allow the administration to focus on certain individuals only rather than everyone. That's what the Trump's administration was doing. They were saying, we're going to deport everybody, creating tremendous backlog. All right, so Biden administration is going to now Supreme Court to stay court order blocking it from setting immigration enforcement priorities. We hope, of course, that the Supreme Court will allow for the lowest court decision to be blocked. In the meantime, while the fight is going on, we're going to see what's going to happen. For you, for a person who is in removal proceedings, so maybe in removal proceedings, currently it means that, number one, of course, you have to be careful. Number two, you have to be prepared. You have to collect your records, as I told many times before, records showing that you have ties with the United States, copies of birth certificates for your children, marriage, documents regarding your employment, your business, you're paying taxes, just in case, right? And if you can, ask for prosecutorial discretion. I'm telling you right now that the prosecutors in court are still exercising their prosecutorial discretion to opt for dismissal of the case or administrative closure of the case in certain situations. And when you ask for it, you just don't mention the memo in controversy. Just don't mention it. But they do exercise it. So that's where we are at with regard to prosecutorial discretion and enforcement. I know that some states are eager to start deporting everybody, like Texas. So just keep that in mind. Keep that in mind. And we hope for the best, right? Good news we have now for nationals of Venezuela. Remember, in my previous video, I mentioned that the designation for TPS for Venezuela was about to expire if it would not be extended on July or by July 11th. And on July 11th, the DHS extended extended TPS designation for Venezuela. So many people are asking me, well, can I file for TPS? What is TPS? TPS is a temporary protected status. It shields one from being deported. It provides, if you file for it, a work authorization, employment authorization, and it also gives you an opportunity to travel, right? If you file for the travel document and grant travel document. It's not, however, a green card. It's not specific status that would lead by itself to a green card. And not everyone can file for it. In fact, there is a list of countries, here we go, that are qualified for, nationals of which are qualified for TPS. Not everyone. So nationals of Afghanistan, Burma, Cameroon, El Salvador, Haiti, Honduras, Nepal, Nicaragua, Somalia, Sudan, South Sudan, Syria, Ukraine, Venezuela, and Yemen do qualify for TPS, but not anybody else. Can you qualify for TPS if you have dual citizenship? You may. I would say that if you do have a dual citizenship or passport of another country, not only the country that is designated for TPS, imagine, for example, somebody is a citizen of both Venezuela and Argentina. Argentina is not designated for TPS, but Venezuela is. Can you still file? You may. However, you have to be prepared to defend yourself from USCIS potential argument, depending on your circumstances, that you firmly resettled in a different country. So by itself, dual citizenship would not disqualify you from TPS, but you have to be prepared for the fight, okay? Now, can you travel with advanced parole that you receive if you hold TPS status to certain countries, including your home country? Yes, you can. In fact, there are no restrictions known to me as to which countries you can travel to if you receive advanced parole when you hold TPS status. The best thing, of course, about TPS is that it shields you from deportation, and you may feel safe, and you don't have to worry about this lack of enforcement priorities memo, who's going to come to power in 2024. For that reason, I always advise everyone who may qualify for it to always apply. Because remember, if you don't file for TPS during the initial designation, you will lose an opportunity to file for it later. So it's like sort of a chance that you have to use, or you lose it. So good news for people from Venezuela. Hopefully, what's going to happen is that some other countries are going to be designated for TPS, or redesignated rather, and will feel safe as well. Or nationals of those countries will feel safe as well. Now we're going to talk about one more important piece of information. It's flexibilities that USCIS was providing to applicants, petitions, in connection with COVID measures. And we're referring to extensions of time that one would have to reply to a request for more evidence, or notice of intent to deny, or file an appeal, for example. So as you see from the screenshot, for example, if certain requests from USCIS were issued between March 1st, 2020 and July 25th, 2022, including request for evidence, notices of intent to deny, to revoke, to rescind, motions to reopen, and 400. you would have not just the time that is specified in the notice to respond, and usually it's 30 to 90 days, but you also would have additional time if your notice for request was issued within this window. So, for example, you receive a request for more evidence dated July 25, 2022. And in the notice, it says that you have to submit your evidence within 90 days, or like they say, usually 86. You would have additional time, not just this 90 days, but plus 60 days after the due date set to respond to this request. It means that USCIS is going to accept your late filing. They're going to give you this window. But this is coming to an end. It seems that you have to, again, rely after July 25, if something is issued to you, on the dates that are specified in the letter. And don't think that unless there's a special announcement that's going to follow, if there will be a special announcement, only then you'll be able to enjoy extra time to respond to requests for more evidence or submit an appeal. But rumor has it that those days are over. And after July 26, if something is dated July 26, you will have to submit your answers, responses to USCIS timely. Very important to know. And last thing I wanted to tell you, very interesting, USCIS is concerned that not everybody is filing for citizenship. Imagine it says that 9.1 million lawful permanent residents may be eligible for naturalization, but you guys are not filing. Why? What's holding you back? Is it high fees? Maybe it's legal issue. You're afraid that if you file for green card in the United States, your home country is going to force you to give up the original citizenship. I do not know. But USCIS is concerned about that, and they actually developing a new program. It's called US Citizenship. It's called something Ambassadors Program. They appoint 8 citizenship ambassadors to promote importance and opportunities of citizenship in communities nationwide. There will be 8 people who are known in their communities for being very active, who's going to, free of charge, speak on behalf of USCIS and organize different events and programs to promote and encourage you guys to become US citizens. So currently you can, check the requirements at USCIS website, Form N400. There is a filing fee for it, $725. So perhaps that was holding people back. But overall, I think everyone who qualifies should file for citizenship. It's a good thing to have United States citizenship. So this is what I wanted to share with you today. And now, if you have questions, I will be happy to answer some of them. Hi, Fazil. Hi, Surbriana. Hi, Alfredo. Hi, Kamlesh. Don't forget, guys, to let me know where you're watching from. Hi, Ranjihan. Hi, Alfredo. Hi, Farhana from California. That's nice. Hi, Tia, Fort Myers. Hi, Akuna, Philadelphia. Yay. Manoj, Chicago. Hi, Sanwal, Pakistan. That's nice. Hi, Takur. I have 2 cases, asylum and marriage. I came in illegally. Enter. I waive I-601A waiver apply, time over. I think your question relates to the fact what you can do if you have a marriage-based case and you have asylum pending. You see, if somebody is filing for asylum, they do not have to show that they entered the United States legally. In fact, anyone who is in the United States can file for asylum. Well, you have to meet qualifications for it, of course. You have to show that you're going to be persecuted in your home country if you return there or you were persecuted. Marriage situation is very different. You must show usually that you were admitted or inspected into the United States. Sometimes if a person travels based on advance parole, that would be considered paroled to the United States. And that's how a person may satisfy this requirement. And of course, for marriage-based case, guys, you have to show that the marriage is real. It's very important. It's the most important thing. I'm going to tell you that if you have concerns that you will not be able to show it, consult with an attorney. Don't start the process by yourself. Why? Because if something happens and you're denied, the USCIS believes that your marriage was entered for the purposes of obtaining green card only. You potentially will never be able to fix your status in the United States, or it will be extremely difficult. Because under the law, if you are denied based on something called 204C, or if the government suspects that you committed marriage fraud, no petition by a new spouse or an employer or self-petition may be approved for you. Okay, so your options will be very, very limited. So keep this in mind when you're evaluating what's better for your marriage case or asylum case. They are very different, two very different cases, and you have to speak with an attorney to see if you can qualify. And for I-601A waiver, just you need to know that usually when you file for I-601A waiver, you have to travel to your home country for an interview. So same country you're asking asylum from, something to talk with your lawyer about, whether it's going to be a good idea. Hi, Josephat. Hope you'll find time to also touch on the affirmative asylum cases. Guys, some people ask me this question every single time, but honestly, if I could, I would have processed all the cases as fast as I could. But the problem is that some people wait for 5 years. Sometimes people tell me they wait even longer, for 7 years. And you guys are in backlog. And every now and then I issue a video updating you guys on the backlog. Basically, why there is a backlog? Because there are close to 200,000 new applications that are being filed every year in the United States. The order in which those applications are being considered is last file, first going for the interview. So naturally, cases that were filed in 2017, let's say, are always going to be in the back because there are so many new cases. I know that the Asylum Office did hire new officers to address just the backlog, but I believe there are, 150 of them or so? And I calculated it once. I think if they only did this, nothing else, it would take them 2.5 years without the new filings to go through this tremendous backlog. So listen, if you have an opportunity to fix your status somehow else, let's say you marry a US citizen, you can show you have a real marriage, go for it. Because asylum cases will take a while. I think overall, only 30% of all the cases are being called right now. And the rest of the cases that are being called for interview are newly filed cases and cases that previously rescheduled. So imagine, I mean, I don't want to say that there is no hope, but it's gonna be wait time. Hi, Ramjihan. Hi, Shahid. Hi, Wasim. Thank you very much, Wasim, for your kind words. Let's see. Hi, Farhana. What is the chances of PD if someone is eligible and two kids are citizens and one is on DACA? Parents have clean criminal background. PD in the form of what? And what were you filing for? Absent fraud, right? And if you potentially may be able to adjust your status down the road based on your children's citizenship, you may ask for your case to be administratively close to dismissed. In fact, I think prosecutors prefer dismissal, so you're out of their hair, okay? You're out of their hair. Of course, if there is fraud or some other concern in the case, the factors were actually mentioned in one of the memos. For example, marriage fraud, overall fraud, danger to public safety or national security, then the prosecutors are not going to agree to the prosecutorial discretion. And without the agreement, the judge is not going to close the case. All right, I know that for a fact because we filed once and I didn't hear from the prosecutor and I filed for administrative closure and the judge said nope. And then the prosecutor finally had time to review the request and they agreed to dismiss the case and then everything went well. So, you know, hopefully it shouldn't be a problem for you if you have a clean record and no fraud in your file. Then, and another thing, do you want the case to be dismissed? You do understand that if the case is dismissed, you first of all losing your employment authorization, and second, you will not qualify for the relief you were seeking, right? If you're seeking asylum, for example, I don't think you'll be able to renew it afterwards if the case is closed. So that's something to think about, something important to think about. All right, let's see what else we have. Hi, Arnold. Hi, when can I expect I-45 interview after VAWA approved? I sent my I-45 in May after I-360 approved, and my case shows fingerprints taken 50 days ago. First of all, why do you think there will be an interview? Very often, when you have I-360 approved, there is no interview for I-45. So it's a good news, right? The bad news is it may take a year and a half to get to that point. So it's probably going to take way longer than you expected, sweetie. It's not going to be anytime soon. Usually, it takes literally like a year after I-360 is approved nowadays for your I-45 to be considered. An interview may happen, but it's better if it doesn't, because if the interview happens after VAWA is approved, it means that the USCIS thinks there is an issue in your case, okay? So this is something that you need to know about. Let me see. Hi, OJZ. Can I qualify for TPS if I entered the United States in 2016? I'm Salvadorian. I don't remember every country's designation and time, but I think for you, and again, I'm not giving you legal advice here, just a tip, but it's very easy to check. You're going to go to USCIS website and you're going to type out TPS designated countries. And if I'm not mistaken, you have to reside from a certain time if you're from El Salvador. You want me to check now? I can quickly check for you to see if you qualify for TPS, right? Because each specific country has their own conditions. For example, this is what it says: temporary protected status, designated country El Salvador. TPS continued through, while there is a lawsuit about that, continuous residence in the United States since February 13, 2001. You see how fast I could check that? So if you entered the United States in 2016, it doesn't seem like you're going to qualify for TPS if you're from El Salvador, okay? If, however, the government does not redesignate the country. It's very interesting. Sometimes what they do is that they change this date since which you have to show you've been residing in the United States. It happened, if I'm not mistaken, to nationals of Haiti. They also had to show that they entered from the time immemorial, and this year or last year, the date was changed to the most recent date, which is amazing because some people were able to take advantage of this, right? If you missed your original deadline. So I feel like El Salvador should really, and is up to that point where they have to redesignate it again. And I've been talking about it before in some of my videos, but so far it has not happened. Maybe because of this lawsuit that's going on. Because there was a lawsuit, the Trump administration decided to end TPS for El Salvador, and then there was a lawsuit that was on pause, and it's kind of a mess, you know. But yeah, 2016, according to the data on USCIS website, is unfortunately not going to help you out here. But maybe there will be some other options, you know. All right, so let's see if we have some more questions. Hi, PF4. Hello, how are you doing? I'm doing fine. What's your advice about if I've been rejected at the US Embassy immediate relative visa in 2020 and I reapplied again and I'm very close to the interview? What's my advice? I have no idea. You see, to get my advice, we need to have a consultation, okay? But generally speaking, I can tell you that if something happened during the previous visa interview and you were denied, you have to address, if possible, the reason for the denial. What happened? Was your I-130 revoked and sent back to USCIS, and then you were able to clear that up? Did they say that you didn't have, or your sponsor didn't have enough income? Did they accuse you of some sort of inadmissibility, like a criminal conviction, and you were able to show that that criminal conviction actually is not a problem? I do not know, but all I know that you should work with an attorney if you had a previous denial, and you have to address the reason, if possible. Not every reason can be addressed, okay? Just so you have to know that. Just sometimes just reapplication is not going to cure the situation if it's a permanent issue. In certain situations, unfortunately, it is. Hopefully, it's not your case. So, guys, thank you very much for watching me. It was a pleasure, really. Please like, share this video, sign up for my YouTube channel, my Facebook, if you have not done so. I regularly provide these little updates with regard to the most recent immigration issues and answer some of you guys' questions for free. And always, always a pleasure to see you all, and I hope to see you soon.